And so let's just take a step back here. Let's first break down, if you could, the Clintons' argument. I want to talk about some things that they said, because here's how their legal team described the subpoenas. They said they were invalid and legally unenforceable, untethered to a valid legislative purpose, unwarranted because they do not seek pertinent information, and an unprecedented infringement on the separation of powers. How strong is their argument here that the subpoenas cannot be enforced?
Well, Brittany, of the litany that you just mentioned, there is one key point, and that is the information sought relevant to the congressional inquiry? One of the elements of the crime here is that there are three main elements. One, you have to be summoned. Two, you have to have willful noncompliance, which a letter stating that you refuse to comply is pretty strong evidence of that. And third, the Congress will have to show that they were seeking relevant information. And so the Clintons' letter stating that this was not for any lawful purpose and that there was no relevant information to find is a possible defense here.
I do want to pick your brain about what has been reported as an off-ramp compromise that the Clintons' team tried making with Comer's team. They said that they would have a meeting under oath in the former president's office. Comer would be there, as well as the ranking member of the committee, as well as a staffer each. They would have this meeting. Comer rejected it, but do you think the Clintons could use this as a sort of defense and say, hey, well, we tried speaking with you here?
You know, as far as a defense to the elements of the crime as defined, Brittany, I don't think that's a legal defense. Certainly, it's something that the House can take under consideration in terms of deciding whether to eventually move forward with a trial in the matter. And so the House could decide, in light of all the circumstances, that the Clintons' willfulness and not complying was more excusable in this case, and maybe they shouldn't move forward. But at the end of the day, they did send a letter saying they were going to refuse to comply with the summons. So while not a legal defense, it might still serve to get them out of some hot water.
The Clintons also argued that they're being held to a different standard here, that other people were issued subpoenas, other officials, and they gave written testimony, and the House committee thought that was enough. The Clintons said, hey, we gave written testimony. You're still trying to march us in here. It's a political performance, essentially. Does that bolster their argument at all?
Brittany, those are all relevant considerations in the big picture of what's going on. And we see this not only with prosecutions of political figures, in circumstances like this, but even in the day-to-day criminal prosecution and defense system. All cases are not treated equally. And so it's again, while not a legal defense saying other people were treated differently, it may serve to bolster their position in negotiation and perhaps, cut off at the pass the idea that the House is going to want to take them to trial.